The House Judiciary Committee hearing room buzzed with tension as former Florida Attorney General Pam Bondi leaned forward into her microphone. The congressional investigation into election integrity measures had been underway for nearly 2 hours, with Bondi serving as the Republican-invited expert witness. Her testimony had been forceful and pointed, particularly when addressing Democratic representatives. As Congresswoman Jasmine Crockett's questioning period began, Bondi's expression shifted to one of barely concealed dismissal. The freshman representative from Texas had been allocated 5 minutes for questions, but Bondi seemed determined to control the exchange from the outset. "Congresswoman," Bondi began with a condescending smile before Crockett had even posed her first question. "Before you start, I have to ask, do you actually understand how election systems work? Because your previous comments suggest a fundamental misunderstanding of basic electoral processes." The chamber fell silent at this unprecedented breach of decorum. Committee members exchanged shocked glances as the camera caught Crockett's momentary surprise at being addressed in such a dismissive manner by a witness. Congressional hearings followed strict protocols, and witnesses questioning representatives' qualifications or intelligence represented a serious departure from those norms. For a moment, Crockett sat perfectly still, her expression unreadable. Then she calmly adjusted her microphone and looked directly at Bondi. "Ms. Bondi," she began, her voice measured but firm, "I appreciate your concern about my understanding of election systems. Before I address that, I wonder if you could tell the committee about your own qualifications in this area. Specifically, how many election law cases have you personally litigated in federal court?" The gallery stirred as Bondi's confident expression faltered slightly. What happened next would transform a typical committee hearing into one of the most memorable congressional exchanges of the year, and leave the normally poised former Attorney General visibly shaken and scrambling to maintain her composure. Before we reveal Bondi's response and the devastating sequence that followed, make sure to like this video and subscribe to our channel for more political analysis that mainstream media won't show you. You won't want to miss the moment that exposed the danger of underestimating a former federal litigator in a congressional hearing. Pam Bondi and Jasmine Crockett represented two distinctly different paths through American law and politics. Bondi, 58, had built her career as a prosecutor in Florida before being elected as the state's first female attorney general in 2010, a position she held for 8 years. After leaving office, she had transitioned to the national stage, serving briefly in the Trump administration and subsequently becoming a regular political commentator on conservative media outlets. Throughout her public career, Bondi had cultivated an image of polished professionalism combined with aggressive advocacy. Her communication style was direct and often confrontational, characteristics that had served her well both in the courtroom and in political debates. With her carefully styled blonde hair and designer suits, she projected an image of confident authority that resonated with her political base. Since leaving the Attorney General's office, Bondi had positioned herself as an expert on a range of legal issues, particularly election law and integrity measures, despite limited direct experience in those specific areas of practice. Her appearances on news programs frequently featured definitive pronouncements on complex legal questions, delivered with a certainty that came from years of speaking as her state's chief legal officer. Across the political divide sat Representative Jasmine Crockett, the 42-year-old Democratic Congresswoman from Texas. Before entering Congress, Crockett had built her career as a civil rights attorney, representing clients in high-stakes federal litigation and developing particular expertise in voting rights cases. This legal background had given her first-hand experience with the complexities of election law that far exceeded that of many of her congressional colleagues. Unlike Bondi's carefully cultivated public image, Crockett was known for a more straightforward approach that reflected her courtroom experience. Her communication style combined legal precision with an authentic directness that sometimes caught political opponents off guard. Where Bondi excelled at confident assertion, Crockett specialized in methodical questioning and evidence-based arguments. The conflict between these two legal professionals had been brewing since the House Judiciary Committee announced its hearings on election integrity and voter access 2 weeks earlier. When Republicans named Bondi as their expert witness, many were surprised given her limited background in election law specifically. Democrats had countered by naming former voting section chief of the Department of Justice Civil Rights Division, Margaret Chen, whose 3-decade career had focused exclusively on voting rights and election administration. In the days leading up to the hearing, Bondi had made several media appearances criticizing Democratic positions on voter ID requirements, early voting periods, and mail-in ballot procedures. During a particularly pointed segment on Fox News, she had specifically singled out Crockett, describing her as another progressive representative who wants to undermine basic election security for political advantage. This public criticism had not escaped Crockett's attention as she prepared for the hearing. "She's positioning herself as an election law expert to a national audience," Crockett had told her staff during preparation. "Let's review her actual litigation experience in this area before tomorrow's session." What Bondi couldn't have anticipated was just how thoroughly Crockett had researched her professional background in the days before the hearing. Working with her legislative staff and former colleagues from her litigation practice, Crockett had compiled a comprehensive analysis of Bondi's actual case history in election law, or more accurately, the notable absence of such experience. There's a significant difference between political talking points about election systems and actual experience litigating election cases, Crockett had noted during preparation. That distinction seems particularly relevant given Ms. Bondi's positioning as an expert witness. The stakes extended far beyond personal political reputations. With election procedures becoming increasingly contentious and several states considering significant changes to voting regulations, the committee's findings could influence policy decisions affecting millions of voters. For Bondi, the hearing represented an opportunity to reinforce her status as a conservative legal authority and potentially position herself for future political opportunities. For Crockett, it offered a chance to bring her substantial voting rights experience to bear on policy discussions that would affect the fundamental right to vote. As the hearing began that Thursday morning, observers anticipated standard partisan exchanges about the balance between election security and voter access. What they couldn't have predicted was how Bondi's unexpected breach of protocol in questioning Crockett's qualifications would create an opening for a devastating response from someone whose litigation credentials she had seriously underestimated. Do you think witnesses in congressional hearings should be required to have direct professional experience in the specific topics they're testifying about? Or is general legal and policy knowledge sufficient for providing expert testimony? Share your thoughts in the comments. We're interested in your perspective on what qualifications are necessary for someone to be considered a genuine expert in complex policy areas. The House Judiciary Committee hearing had begun with the standard formalities, as Chairman Jim Jordan outlined the purpose of the day's session. Today's hearing on election integrity and voter access aims to examine current systems and proposed reforms to ensure both security and appropriate access to the ballot, he explained before witnesses delivered their opening statements. Pam Bondi's testimony had been delivered with characteristic confidence. For nearly 15 minutes, she outlined concerns about voter identification procedures, ballot harvesting, and non-citizen voting, issues she described as critical vulnerabilities in our election systems. Throughout her presentation, she maintained the authoritative tone of someone with extensive specialized expertise, making definitive pronouncements about technical aspects of election administration. States that have implemented robust voter ID requirements have seen virtually no decline in legitimate voter participation while significantly enhancing public confidence in election results, Bondi asserted, despite substantial academic research suggesting more complex outcomes. The real voter suppression, she added pointedly, is the degradation of election integrity that makes Americans question whether their legal vote matters. When questioning began, Republican committee members had provided Bondi with opportunities to expand on these themes, asking broad questions that allowed her to deliver what appeared to be pre-prepared responses about election security measures. Throughout these exchanges, she maintained the confident demeanor of an authoritative expert, frequently prefacing statements with phrases like, "in my extensive legal experience," and "as someone who has worked directly with election systems." The tone shifted noticeably when Democratic representatives began their questioning, with Bondi becoming more defensive and occasionally dismissive. Her responses to technical questions about specific provisions of voting rights law sometimes wandered into general principles rather than addressing the legal details directly, though her confident delivery style obscured these pivots from specific to general for most observers. When Congresswoman Crockett's 5-minute questioning period began, the anticipation in the room was already elevated given Bondi's earlier critical comments about her in media appearances. No one, however, anticipated Bondi's immediate breach of protocol in questioning Crockett's basic understanding before the Congresswoman had even posed her first question. "Congresswoman," Bondi had begun with that condescending smile, "before you start, I have to ask, do you actually understand how election systems work? Because your previous comments suggest a fundamental misunderstanding of basic electoral processes." This unprecedented departure from hearing norms created the moment captured in the opening scene. After a brief pause to register the impropriety, Crockett had responded with remarkable composure. "Ms. Bondi, I appreciate your concern about my understanding of election systems. Before I address that, I wonder if you could tell the committee about your own qualifications in this area. Specifically, how many election law cases have you personally litigated in federal court?" Bondi's expression flickered with momentary uncertainty before she recovered her practiced poise. "I served as Florida's Attorney General for 8 years, overseeing all aspects of our legal system, including election matters. My office handled numerous election-related issues during my tenure." Crockett nodded thoughtfully. "That's a very general answer, Ms. Bondi. Let me be more specific. As Attorney General, did you personally litigate, meaning you signed pleadings and appeared as counsel of record, in any federal election law cases?" Bondi shifted slightly in her seat. "As Attorney General, I supervised legal teams that handled various matters. I didn't personally appear in every case my office oversaw." "I understand the role of supervision," Crockett replied evenly. "So the answer would be no, you did not personally litigate any federal election law cases. Is that correct?" Bondi's jaw tightened visibly. "My role as Attorney General was executive in nature, directing the state's legal strategy rather than handling individual cases myself." "Thank you for that clarification," Crockett continued. "Let me ask a different question. Prior to becoming Attorney General, as a state prosecutor, did you litigate any election law cases at any level?" "My background was in criminal prosecution, which provided a foundation for understanding legal processes generally," Bondi responded, her earlier dismissive confidence noticeably diminished. "I'll take that as another no," Crockett noted calmly. "Since leaving the Attorney General's office, have you litigated any election law cases in any capacity?" Bondi's expression had now shifted from condescension to discomfort. "I've been involved in election issues in various advisory capacities." "Advisory capacities," Crockett repeated, "but not as litigating counsel in actual election cases. Is that correct?" "I've provided expertise based on my comprehensive legal background," Bondi insisted, avoiding the direct question. Crockett nodded again, then shifted approach slightly. "Ms. Bondi, I'm asking these questions because your opening question to me suggested I might not understand election systems. For the record, before joining Congress, I personally litigated 17 federal cases specifically involving voting rights and election procedures. I served as lead counsel in federal litigation challenging discriminatory voter ID provisions, improper voter roll purges, and unconstitutional restrictions on ballot access." The contrast between their respective experiences hung in the air as Crockett continued. "I've deposed election administrators from 6 different states, cross-examined expert witnesses on election security technologies, and presented oral arguments in 3 different federal circuit courts specifically on election law matters. This isn't general legal experience. It's direct, specific litigation experience in the precise area of law this hearing is examining." The committee room had grown remarkably quiet as the power dynamic of the exchange shifted visibly. Bondi, who had begun by questioning Crockett's basic understanding, now appeared increasingly uncomfortable as her own comparative lack of specific experience was methodically exposed. Crockett continued her questioning with precision that reflected her litigation background. "Ms. Bondi, in your testimony you stated that voter ID laws have had virtually no impact on legitimate voter participation. Are you familiar with a peer-reviewed study published last year in the Journal of Politics analyzing turnout data from 2008 through 2020 across jurisdictions with varying ID requirements?" Bondi hesitated. "I'm familiar with various studies on the topic generally. This specific study, which I have here," Crockett said, holding up the document, "found statistically significant decreases in participation among elderly, low income, and minority voters in states that implemented strict photo ID requirements without adequate accommodative measures. The decrease ranged from 3.6% to 8.2% depending on demographic factors. Were these findings reflected in your testimony today? Studies can be found supporting various positions, Bondi replied, clearly uncomfortable with a specific challenge to her earlier categorical statement. Indeed they can, Crockett agreed, which is why expertise in this area requires familiarity with the actual research literature rather than general impressions. Let me ask about another specific claim in your testimony. For the next 3 minutes, Crockett systematically addressed several of Bondi's most definitive claims, in each case citing specific contrary evidence from peer-reviewed research, court decisions, or official election administration data. Throughout this methodical deconstruction, she maintained a professional, non-confrontational tone that nevertheless clearly established the contrast between evidence-based analysis and political talking points. As Crockett's allocated time neared its conclusion, she returned to Bondi's opening question about her understanding of election systems. Ms. Bondi, I want to address your initial question about whether I understand how election systems work. Based on our exchange today, I think the committee can evaluate which of us has demonstrated specific knowledge of election law, research, and administration. She paused briefly, then delivered the exchange's most impactful line. In my experience litigating complex cases, I've learned that actual expertise isn't demonstrated by questioning others' qualifications. It's demonstrated by answering specific, substantive questions with specific, substantive knowledge. I hope the remainder of your testimony will focus more on the latter approach. This measured response, delivered without raising her voice or displaying visible anger despite the clear provocation of Bondi's initial disrespect, left the former Attorney General momentarily speechless. The contrast between Bondi's opening condescension and her current discomfort was stark and unmistakable to everyone in the chamber. Chairman Jordan, recognizing the dramatically shifted dynamic, intervened. The gentlewoman's time has expired. We'll now move to Representative Gates for his questions. As the hearing moved to the next questioner, the damage to Bondi's credibility had been done, not through matching disrespect or political attacks, but through the methodical exposure of the gap between her presented expertise and her actual experience by someone whose credentials she had grievously underestimated. The confrontation had reached its pivotal moment, but the most revealing response was yet to come. The decisive turning point came when Representative Matt Gaetz of Florida, normally a reliable ally for conservative witnesses, recognized the precariousness of Bondi's position after Crockett's questioning. Rather than continuing the pattern of broad, friendly questions that had characterized earlier Republican questioning, Gaetz took a more nuanced approach. Ms. Bondi, he began, I appreciate your testimony today on these important issues. I'd like to give you an opportunity to elaborate on your experience with election law matters during your tenure as Florida's Attorney General. Could you describe specific election-related cases or issues your office handled under your leadership? This seemingly supportive question actually created a difficult challenge for Bondi. After Crockett's methodical exposure of her limited direct experience, a vague response would only reinforce the contrast, while attempting to claim more specific involvement risked further questions she might not be able to answer with precision. Bondi attempted to navigate this dilemma with a response that emphasized her supervisory role. Thank you, Congressman. As Attorney General, I oversaw our office's involvement in various election matters, including litigation related to the 2012 and 2016 elections. While I didn't personally litigate these cases, I directed our legal strategy and worked closely with my team on key issues. Gaetz nodded. Could you share with the committee one specific election law case your office handled, and what the core legal questions involved were? This request for a specific example, rather than general statements, created another challenging moment for Bondi. After a brief hesitation, she mentioned a case involving Florida's voter roll maintenance procedures that had been handled by her office, though she stumbled slightly when attempting to articulate the specific legal principles involved. The case centered on compliance with federal requirements while ensuring appropriate maintenance of voter lists, she explained, her normally fluid delivery interrupted by noticeable pauses as she searched for precise legal terminology. The contrast with her earlier confident pronouncements was striking. Where she had previously spoken with absolute certainty about complex election matters, She now appeared to struggle with articulating specific details about a case from her own tenure, exactly the kind of specific knowledge her earlier testimony had implied she possessed extensively. This subtle but significant shift did not escape the attention of committee members or observers. Representative Zoe Lofgren, a Democrat with substantial election law experience herself, built upon this opening when her questioning period arrived. "Ms. Bondi," Lofgren began, "earlier you made several definitive statements about the impact of various election procedures on both security and access. I'd like to understand the evidentiary basis for these conclusions. Are you familiar with the comprehensive study conducted by the National Academy of Sciences on election security measures and their efficacy?" Bondi's expression suggested she was not familiar with this major research effort, but was reluctant to acknowledge this gap. "I've reviewed numerous studies and analyses on election security," she replied vaguely. "This particular study," Lofgren continued, represented the consensus findings of a bipartisan committee of election security experts, including former election officials from both Democratic and Republican administrations. Their conclusions differed substantially from several assertions in your testimony today. I'm curious whether you considered their findings informing your opinions." As Bondi attempted to respond without directly addressing her familiarity with this significant research, the contrast Crockett had established between presentation and substance continued to widen. Each subsequent questioner seemed to approach Bondi with increased skepticism about her specific expertise, regardless of their partisan affiliation. The most revealing moment came when Representative Thomas Massie, a Republican known for his independent thinking, directly addressed the earlier exchange. "Ms. Bondi, I want to return to something that occurred during Congresswoman Crockett's questioning. You began by questioning her understanding of election systems, which struck many of us as unusual protocol for a witness. Given what we've subsequently learned about your respective backgrounds in election law, do you regret that approach?" This direct question about her breach of decorum created a pivotal moment. The hearing room fell silent as Bondi considered her response. Her usual poise momentarily deserted her as she appeared to struggle with a choice between defending her earlier disrespect or acknowledging its impropriety. When she finally spoke, her voice had lost much of its earlier authoritative resonance. "Congressman, in congressional hearings, witnesses and representatives should engage with mutual respect. If my question was perceived as disrespectful, that wasn't my intention. I was simply trying to establish a foundation for our discussion." This qualified non-apology, acknowledging the perception of disrespect without taking responsibility for the actual conduct, satisfied neither the committee nor observers. Representative Sheila Jackson Lee seized on this tentative response during her questioning period. "Ms. Bondi," she began, "you just acknowledged that congressional hearings should be conducted with mutual respect. Would you agree that questioning a member's basic understanding before they've asked their first question violates that principle of respect?" Bondi shifted uncomfortably. "As I said, that wasn't my intention." "Intent aside," Jackson Lee pressed, "would you agree that such questioning from a witness to a member is inappropriate in this setting?" After a moment's hesitation, Bondi conceded, "Yes, witnesses should respond to questions rather than questioning members' qualifications." This admission, extracted only through persistent questioning, underscored how thoroughly the dynamic had shifted since her initial dismissive approach to Crockett. What had begun as an attempt to undermine a member's credibility had instead resulted in the systematic exposure of her own limited specific expertise and a public acknowledgement of her breach of protocol. When the committee recessed for lunch shortly thereafter, the transformation was complete. Bondi, who had entered the hearing room as a confident, authoritative voice on election matters, now appeared distinctly diminished, not through matching disrespect or political attacks, but through the methodical exposure of the gap between her presented expertise and her actual experience. Political observers in the room immediately recognized the significance of what had transpired. This wasn't merely a momentary embarrassment, but a fundamental challenge to how expertise was presented and evaluated in congressional hearings, a context where confident assertion often carried more weight than substantive knowledge until directly challenged by someone with a specific background to do so effectively. As members filed out for the lunch break, several approached Crockett to acknowledge her handling of the situation. "That was a masterclass in how to respond to disrespect with substance," one senior Democratic representative told her, while a Republican member nodded in grudging appreciation, noting, "You made your point without matching the tone. That's unfortunately rare around here." What made Crockett's approach particularly effective wasn't just her specific knowledge, but her strategic decision to respond to disrespect with substance rather than reciprocal disrespect. A choice that had allowed the contrast between their respective qualifications to stand as the central takeaway rather than a typical partisan exchange of accusations. As the afternoon session prepared to begin, political reporters gathered in the hallway outside noted Bondi's visibly subdued demeanor as she returned to the hearing room. The former Attorney General, known for engaging confidently with the press, now moved quickly past the assembled journalists, declining to take questions about the morning's exchange. The victory lay not in embarrassing a witness, but in establishing that substantive expertise, rather than confident presentation, should be the standard by which testimony is evaluated, especially on matters affecting the fundamental right to vote. The repercussions of the Judiciary Committee hearing spread quickly through political and legal circles. Within hours, video clips of the exchange between Bondi and Crockett had gone viral across media platforms, with particular attention focused on the dramatic contrast between Bondi's opening condescension and her subsequent struggles to demonstrate specific knowledge when directly questioned. What made the moment particularly resonant wasn't just the personal dynamic between the two women, but what it represented about broader patterns in political discourse. The frequent gap between confident presentation and substantive expertise, and the rare satisfaction of seeing that gap methodically exposed through substantive questioning rather than personal attacks. Media coverage reflected this broader significance. The Washington Post ran an analysis titled, "When Credentials Matter. The Bondi-Crockett Exchange Highlights Expertise Gap in Congressional Testimony," examining how witnesses with limited specific experience were often presented and accepted as authoritative voices on complex policy matters. The National Law Journal published a detailed comparison of the two women's actual litigation experience in election law, confirming the vast disparity Crockett had highlighted during the hearing. Even conservative outlets acknowledged the significance of the exchange, though with varying perspectives. National Review writer Jonathan Miller noted, "Whatever one thinks of Representative Crockett's politics, her handling of Bondi's inappropriate opening represents a legitimate example of substantive credentials trumping presentation style, a principle conservatives should respect even when it doesn't favor our preferred witnesses." For Bondi, the aftermath brought significant professional challenges. Her upcoming appearances on several news programs were either cancelled or rescheduled, and her previously scheduled speaking engagement at a major legal conference was quietly removed from the program. More damaging still was the circulation of video compilations juxtaposing her most definitive pronouncements on election law with her subsequent inability to address specific questions about the same topics. 3 days after the hearing, Bondi addressed the situation through a written statement rather than direct media engagement. Congressional hearings are meant to be forums for substantive policy discussion. My exchange with Representative Crockett unfortunately diverted attention from the important election integrity issues the committee was examining. I remain committed to promoting secure and fair elections for all Americans. This statement, notable for not directly addressing either her initial disrespect or her subsequent struggles with specific questions, failed to stem the growing discussion about the credentials of expert witnesses in congressional hearings. When pressed by a journalist for more direct comment a week later, Bondi appeared uncharacteristically defensive. "One exchange doesn't define my entire career or expertise," she insisted. "I stand by my substantive positions on election integrity, even if I could have handled that particular moment differently." This response, framing a systematic exposure of limited specific knowledge as merely a momentary tactical error, struck many observers as particularly inadequate given the comprehensive nature of Crockett's questioning. More damaging still was Bondi's evident difficulty in subsequent media appearances when asked specific technical questions about election administration, questions she had confidently addressed in general terms before the hearing but now noticeably hedged on. For Representative Crockett, the aftermath brought increased visibility and substantive policy influence. Sunday political shows sought her perspective not just on election law, but on the broader challenge of ensuring congressional hearings featured genuinely qualified expert witnesses. In a lengthy interview on Face the Nation, Crockett emphasized the substantive rather than personal aspects of the exchange. What matters isn't any individual witness's embarrassment, but whether congressional committees receive accurate, evidence-based testimony on issues affecting millions of Americans' fundamental rights, she explained. That requires witnesses with specific expertise rather than general opinions, regardless of which party invites them. This focus on systemic impact rather than personal political advantage distinguished Crockett's approach in subsequent discussions. When asked whether she took satisfaction from Bondi's visible discomfort during the hearing, she redirected firmly to the substantive issues. What matters is that committees receive testimony from witnesses with actual expertise in the specific matters under consideration, she insisted. That's not a partisan principle. It's about ensuring policy decisions are based on accurate information. Beyond individual careers, the exchange had measurable impact on congressional hearing practices. Several committee chairs, including Republicans, began implementing more rigorous vetting procedures for expert witnesses, requiring more specific documentation of relevant experience rather than general professional credentials. The House Administration Committee, which oversees internal congressional procedures, initiated a review of witness qualification standards and protocols for appropriate interactions between witnesses and members. Perhaps most significantly, the exchange generated broader discussion about the evaluation of expertise in public discourse. Several media outlets produced analyses examining how confident presentation often overshadowed substantive knowledge in political communication, particularly on technical subjects where most audience members lacked the background to evaluate specific claims independently. 6 months after the hearing, the impact on both women's trajectories was clear. Bondi had significantly reduced her public commentary on election law specifically, refocusing on criminal justice issues where her prosecutorial background provided more substantial credentials. Her media appearances continued, but with noticeably more measured claims and fewer categorical pronouncements on technical matters. For Crockett, the exchange became part of a broader commitment to bringing substantive expertise to policy discussions. When asked about her approach during a Georgetown Law School forum, she offered perspective that transcended the specific confrontation. Our political system often rewards confident presentation over substantive knowledge, she observed. Challenging that dynamic requires more than just asserting different positions. It requires methodically demonstrating why specific experience and evidence should matter more than general assertions, regardless of how confidently they're delivered. She continued, that approach isn't about embarrassing individuals. It's about creating standards for public discourse that prioritize substance over style, especially on matters where the consequences of misinformation can affect fundamental rights. This principle, that substantive policy discussion requires challenging confidently presented misinformation with specific evidence rather than matching rhetoric, became Crockett's defining contribution to political discourse. While less immediately gratifying than viral clapbacks or memorable zingers, her methodical approach demonstrated that thorough preparation and substantive knowledge could sometimes achieve what performative confrontation could not. As future congressional hearings unfolded, staff began advising witnesses with a simple but significant caution. Remember Bondi Crockett, don't claim broader expertise than you can demonstrate if questioned specifically, and never question a member's qualifications unless you're certain yours are superior in that specific area. The exchange's most enduring legacy wasn't about election law or partisan politics. It was about creating a template for how prepared public servants could effectively challenge the substitution of confidence for competence, not through matching disrespect, but through methodical demonstration of the value of actual expertise over presentation style. In that sense, Crockett hadn't just responded effectively to a disrespectful question. She had modeled an alternative approach to political discourse that prioritized substance over spectacle, evidence over assertion, and specific knowledge over general opinion. In a political culture often lacking these qualities, that itself represented a significant victory. If you found this analysis of expertise versus presentation in political discourse enlightening, please don't forget to like this video and subscribe to our channel for more in-depth coverage of pivotal congressional exchanges that go beyond superficial headlines. Share your thoughts in the comments below about whether you think congressional committees should implement stricter qualification standards for expert witnesses.